We've got some fresh new young talent doing some things that I know you haven't heard before.
1, 2, 3, listen.
Welcome to Finances, your home for all things financial, investment, money and lifestyle. Hosted and curated by the very talented team of certified financial planners, Burke Britton Financial Partners. So today we've got, or a couple of weeks ago, we had a number of our clients call us after having read an article that was published on ABC News, and we thought we'd talk about that article today. What I thought we'll do is I'll talk a little bit about that article, and then I'll hand over to the two of you to sort of throw your thoughts in. So the article it was dated the 24th of January 2023 by Dr. Muriel Porter, and it is titled, "Before my husband's death, I thought we had our affairs in order. Now I'm dealing with a nightmare of administration." So I'll go straight to the article, and here we go. So for the past 8 years since my husband's Alzheimer's diagnosis, I've been managing all of our finances. When he was diagnosed, we'd immediately set in place enduring powers of attorney and guardianship arrangements, as well as ensuring that all utilities and bank accounts were in joint names. He already had a straightforward will leaving everything to me, and he'd always dutifully signed superannuation documents to say I was to inherit his super after his death. It seems as if we had everything in place, doesn't it? That's what I thought, until he died 2 months ago. I'm overwhelmed now with grief. That is bad enough, but with a nightmare of administration, and the worst of all is with his superannuation pensions. So maybe let's just start with that as a reasonably common theme for not only our clients, but people out there in the preparing stages of losing a loved one. What are the things that most people out there who are people who are getting advice and the people who are not getting advice thinking about in terms of getting their estate in order? By the sounds of it, Muriel and her husband seem to have things in place.
They thought they had it in place. Correct.
I suppose when I look at that, there was already powers of attorney in place, and they thought they had made appropriate nominations in respect to super. So surface level, it looks like there was some preparation that had already been undertaken. So you sort of think, okay, well, everything looks like it's in order.
I think that probably as an analogy, getting a tongue around that, the person who's not an expert, a professional, looking at it thinking, oh, that looks okay. It's like me looking at the tap and thinking it's fine, it won't leak. But when the plumber comes in, he realises that the valve in the tap's about to bust and it's not going to work. You need to have the right eyes looking at stuff like that. Otherwise, you can make assumptions about things that you don't really know. And clearly, the comments made in the article about, I just thought it would revert to me, and if we see that revert word, we start talking about reversionary pension, reversionary beneficiaries, etc. We talk about nominations, binding nominations, non-binding nominations, and there's a range of things, and you look at who can be nominated, who can't be nominated, what are the tax implications of those nominations. So there's a whole degree of layers below someone looking at it thinking, beauty. We've gone to the solicitor, we've got our attorneys in place, we've got the will, who our executors are, and we've talked to the super fund, and when they send out a document, we sign and send it back. Yeah. So you think you've got it all in place.
That statement, we dutifully signed superannuation documents to say I was to inherit his super after his death. There's a few more questions you'd want to ask there.
Exactly right. And there's much more, depth that needs to go to, because it isn't as simple as saying one person will get it after my death. There's a whole range of possibilities with that document. The nomination document.
One of the most common misconceptions, which I think we spoke about on at least a couple of our previous podcasts, was that superannuation isn't by default an estate asset, which most people do believe. They've got wills in place, even though powers of attorney don't relate to your estate planning. Wills in place means that my super will go as a part of my estate, which is, it may do, but it also may not. And that probably leads us to the next point. So if I go back to the article, the heading is payments simply stopped. Once the two super funds were notified of my husband's death, the pensions simply stopped. Yes, they stopped without any warning, without any notification. The monthly pension payments are no longer turning up. If I didn't have a small pension myself, a little money in the bank, and a daughter ready to help if I needed, I would have been in a very dire financial situation. I might just pause there for a minute and let's just talk about why would that happen? Like, why would that happen, that all of a sudden she's thinking that her pension payments or her late husband's pension payments would simply continue to her, yet upon his death, they've simply stopped.
Well, I guess the starting point with that is that what was in place was not what she thought was in place and what she assumed was in place. And because there are a range of different possibilities about how you can design your super entitlements to be distributed where you want them to go, what her assumptions were, thinking that they'd done the right thing. It was completely not the case. Now, if she wanted to have those pensions continue, if that was what she and her husband wanted, then she needed to make sure that it was very clearly a reversionary pension nomination, which is quite distinctly one of the categories of beneficiaries that are possible, or nominations that are possible. And I think one of the things that comes up when our clients start discussing this is that we need to talk to them about all the range of possibilities, all the things and what their intent is or their wishes are, respectively, for each other in a member of a couple, or when you've got complex blended marriages, there's a whole range of possibilities how you might do that. I think you made the point, Jay, a moment ago. We need to make it really clear to all of our clients that superannuation rules sit very separate to the estate, your will situation. And that's critical. And if clients just think, it'll go through my will, well, it won't unless you tell it to.
And it's particularly alarming for particularly retiree clients where the bulk of their assets, Delta, are in super. So
Absolutely.
a couple of client calls, well, there was more than a couple of client calls about reading this article. Obviously, a lot of the urgency and uncertainty around it was that they're talking about superannuation and the bulk of my assets are sitting in super. Am I at risk?
Jay, if I just sidetrack a little, if we talk about why super doesn't form part of your estate. So I'm not sure if this has been covered previously, but there was an understanding by the governments that super would be used to draw down upon in retirement. And because there's a minimum amount you have to draw that increases as we age, there was an expectation that our super wealth would effectively be depleted by the time that we were no longer here. So clearly, that's not the case where we have a large pool of capital still available that we want to generally have a legacy for our children and so on. So we've sort of arrived at a situation where, the intention hasn't been what's come to fruition. So that's, for anyone that was wondering why, that's why.
I think that point too, that's where the superannuation, they're controlled by trustees, and that trustee needs to be given very clear direction about what you want done if you happen to die before life expectancy. And I guess, with the standard rules as they used to be, by about life expectancy, the money was supposed to run out. Well, people often don't last to life expectancy. That's just a sad fact. And what do I want done with it? Well, I've got to tell the trustee very clearly. And these days, the rules are a bit kinder. You're allowed to accumulate or continue to have funds that can be passed on through your estate. But the existing rules still mean you've got to tell the trustee of the super fund, whatever that super fund is, you've got to direct them very clearly, the legal requirement, or sort of legally tell them what you want done with the money. And the trustee still has discretion in some instances. That's the thing, isn't it?
That's a perfect segue into the next part of the article. So I'll go back to the article. It seems that my husband's regular notifications to the funds that his pensions were to revert to me on his death were close to meaningless, leaving me struggling with the endless paperwork the super fund now required. There are detailed application forms to be completed when I can get the right forms, that is. One super fund keeps sending me the wrong form. I've rung them several times, gone through all the details again and again, only to be told that though this has been ongoing now since well before Christmas, it'll take 10 business days before a form is likely to be sent, so I just have to wait, it seems. That's not all. I have to get certified copies of my husband's birth certificate, my birth certificate, our marriage certificate, his death certificates, the probate document, and his will. So what does that say to you about the type of nomination that has been made in this instance and what that then requires of a surviving spouse?
I think that the terminology that she's used shows very clearly a misunderstanding of exactly what was in place. And she's talking about reverting to me when I die, and, my husband's entitlements will be mine when he passes. Clearly, what she assumed was being done with the nomination forms was not what, in fact, the super fund and the trustee of the super fund were holding and going to be acting upon. So she obviously didn't have a binding reversionary pension nomination. Like, there was not a binding legal requirement on the trustee to continue the pension to her in the event her husband passed. That was clearly not done.
So that doesn't mean that she won't be the ultimate recipient of that money. But what it does mean is that the super fund has to use their discretion, and regardless of whether or not she is his long-term spouse, the super fund is obliged to actually go through that process and
takes time.
Request all of that information, request all of those forms, which...
legal requirements. They've got no choice. Yeah, spot on. And that's the sadness. And again, probably a good... The article was good in the sense that it alerted, well, it caused a handful of our clients to make contact with us to say, gee, I don't like the sound of that. How are we situated? Now, the good thing out of that was that in that conversation with those respective clients, we're able to very clearly say, righto, looking at the article, the issues that woman had, now what we are doing with you is we have this in place, and whether it be a reversionary or binding nomination or it's split up as you wish across the various people, in your estate wishes. So we could talk through very clearly with the client what was in place and what we had already talked through and prepared for them to make sure that their wishes would be executed very quickly, and the trustee wouldn't have the discretion or wouldn't have the necessity of trying to look through possible alternatives. Binding trustee nominations that the trustee has no choice about is pretty important.
It probably makes things more streamlined, doesn't it?
It sure does.
It's a difficult time.
Yeah, so if I go back to the article and read this paragraph, it says, I'm told it will take quite some weeks for their trustees to assess the situation and decide if I'm truly my late husband's heir. Again, trustee using their discretion because they have to by law.
No choice, yeah.
You would imagine that super funds would be used to dealing with this situation, and she says, surely they could have a streamlined process in place. So
that goes back to the reversionary nomination, which we all look at and think, well, that's what you don't have in place. You didn't have an automatic reversionary nomination. Therefore, we have to go through this process. And I suppose the key there is that that nomination needs to be made at the time the pension is commenced. So it shouldn't be an afterthought. It should be a part of the, initial discussions and understanding of what would happen in this scenario. I don't know how technical we want to get, but we haven't even talked about the fact that, super can be in accumulation phase or pension phase. So what happens if you, are in either of those two phases? You can have both, and potentially you want to have beneficiaries who are different across each of those accounts. So I suppose it's complex and it needs addressing at the early stages when we look at what the future implications might be.
Yeah, and although it's kind of a nebulous response, when people ask, well, what should I do? The answer is it depends.
Well, it depends. What do you want?
Yeah.
What do you want it to look like?
So does my spouse need for pension payments or income to continue straight away in the event that I'm no longer here? We'd have to be thinking about a pension reverting immediately. There may well be some other circumstances where that might not be the case.
Yeah.
It might not be the case that reverting to a pension is right. And maybe in some instances, leaving the discretion or leaving some discretion is appropriate. Again, there's so many different instances. And I suppose to the author's point, there are ways of streamlining your superannuation and the direction of it through your estate plan, but it does require effort. And it sounds as though herself and her husband had put effort and energy into making sure their estate plans were in place. But even in doing that, they've missed or misunderstood or haven't had a total appreciation of exactly what was going to happen in the event of death. And that is not uncommon.
No, it's absolutely not uncommon. And I think one of the things that when we're talking to a new client, prospect coming in, talking about what they might want to do almost without exception, one of the conversations is around their estate planning and what's being done with their superannuation or pension beneficiary nominations, because that is a critical part of putting together plans. And most people, when you sit down and go through that analysis of what they're trying to achieve, one part of it, and again, the conversation or the comments made by the two of you in a few meetings about not, planning the worst case scenario, not, wishing you to be dead. But if we don't plan when things are great, then plans go to shit when things go to shit. Like, it's really important when everything's in good shape, you make decisions. When one husband's not got Alzheimer's, like, You do all that stuff way in advance, and it's always changeable, but it's important to have those thoughts about what might it look like, what do I want it to look like. Let's write my script about when I go to God, what is it that I want done with the assets that I own that are in my name and I've got control over. Unless you put that script in place and have a discussion with the individuals around what it is they want it to look like, you can get it a little bit wrong. And a little bit wrong at times like this article, can be really big wrong. And those stresses, when you've already got the emotional stress of a loss, you don't want the financial stress. So put all that stuff in place way before these things might happen. Talk through, understand, be really clear, and don't try and fix that dripping tap if you're not a plumber. Like, just find out exactly what this means and what I need to do so I have it streamlined. The super fund are not obliged to streamline it. They have a set of criteria and they'll operate based on what you tell them to do. And so if there's 4 or 5 or 6 different alternatives and you use one of those alternatives, they're bound by law to operate under the requirements of that alternative. So the streamlining needs to come from the person giving directions to the trustee. That's the part that has to happen.
We're a morbid lot, aren't we?
and
Talking about your death.
Yeah, and people's situations change regularly. That's the other thing that we would probably reinforce, is that a will or beneficiary nominations, once set, are not there to be forgotten. Absolutely, they do need to be revisited.
My word.
And it's one of the great things about catching up with our clients regularly, is that we are constantly reviewing their situation, looking at who their executors are, who their powers of attorney are, who their beneficiary nominations are on their supers. And as their circumstances change, we can adjust course along the way.
Yeah, the number of conversations over the years where you've said, okay, let's just have a quick look through, your estate planning. Oh, you've got your friend such and such as your executor. Oh, well, I don't speak to them anymore. Okay, well, might be time to address it and make some changes. So absolutely, that's never a set and forget. And I'm not sure how much detail we'll go through in the article, Jay, but the other thing that jumps out at me here is that you could perhaps call this a bit vanilla, as in, 2 members of a couple and one dies, and the intention is that the benefits ultimately go to the survivor. Imagine if you've got a situation with a blended family unit and there might be, children from one side or the other side, and there's an intention for assets to be
for the
shared.
Adult children to get the superannuation from the first relationship, but the existing spouse is the spousal relationship for superannuation purposes and would receive that tax-free. It's very, very complicated. Even in this vanilla situation, I skipped over a couple of things, but a couple of the other points here for Muriel and her late husband. He was in aged care, and so she had a refundable accommodation deposit that hadn't come back yet. So she had a lump sum that she couldn't access immediately. The other thing, which is the next part of the article, relates to Centrelink. And we all know, having dealt with Centrelink, that Centrelink can be painful at the best of times, but dealing with Centrelink post someone's passing is, like you said, Peter, it's difficult enough when you've lost someone, but to then have to deal with administration and paperwork. Yeah. So let me go back to the article. The superannuation situation will eventually be resolved, but then another problem will have to be dealt with: the Centrelink pension. When my husband's super pensions resume, now that I'm single, I have too much income to qualify any longer for the small age pension. That's okay. I'll simply tell Centrelink to stop it. No, nothing so simple. I'll have to fill in an 18-page form, complete with documentation from super funds, and then I'll have to make an appointment to discuss it with Centrelink consultant, even though I just want the pension to stop. Does it sound
salt in the wounds, isn't it? When you're at that stage where you're reconciling with the grief that you're experiencing, and you have to go through these bureaucracies to make these changes. We see it firsthand.
Yeah, Centrelink, and maybe if you want to talk to one of the benefits, and this is probably tooting our own horn to some degree, but the importance of having support with Centrelink nominees, people that actually know your situation, your income, your asset position, and are able to potentially on your behalf support you by letting Centrelink know of changes.
It's very interesting because only this morning I had a conversation with one of our lovely clients who's now a widow, and it was a blended family, and at the point where her husband had to go into aged care, which is what we're just talking about with this article, there was money that was taken to put toward the RAD, money that agreed was going to be part of his estate, which would go to his kids beyond his passing. And in the same time, there was a change of housing with her where she sold one place, moved to another place to be much, much closer to the aged care facility that was in, etc., etc. And the complexities of that and the emotional time, very emotional time that she had to go through, we've been working with Centrelink right through that process. We've been updating things, and even today, we're still backtracking, trying to get Centrelink to update. But all I need to do is ring this particular client, say, I just need you to drop off when you can a statement from when that particular investment was paid to your bank account. And so all the work is being done. And for us, it's a pain in the butt. And we're still, we're many, many months past him going to heaven, but still, we're still trying to resolve the Centrelink matters. If you're the situation like this lady in the article, when you're dealing with the Alzheimer's situation, your husband in care, and then you've got to deal with all of these financial burdens as well, it's critical to have it set up before it's too tough to deal with. That's I think the first step in the process is have as much support as you can, but also have as many things set up properly before it happens so that it's easier. It won't be easy, but it still will be easier in these times of crisis.
And just quickly on that Centrelink example, we have a client, and sadly, my husband has been quite unwell and has now passed. And, there was an understanding that his health would mean that would be the case. We were able to provide her with some comfort in advance of his passing, what the situation would look like for her, when that eventuated. So I suppose just being, again, proactive. We're not manifesting these things to happen in our client's life. We just want to be prepared while we've got the opportunity to be prepared. And again, when we talk about super and beneficiary nominations, that's just a very small part of our estate. Like we have to take a step right back, don't we, and how assets are owned and the implications for, family members contributing to refundable accommodation deposits with, other family members entering aged care. Like there's just layer and layer upon, complexity when we look at the totality of what might an estate actually look like.
Yeah, a couple might have a whole lot of joint assets. They might have a whole range of joint assets, which, normally a joint asset passes to the survivor in the event that one goes. But if some of those joint assets are used to pay the RAD, the accommodation deposit at an aged care facility, suddenly that belongs to the estate of the person who passed. And again, as this article states, like that money is now locked up for a period of time. You probably have to go through probate. Solicitor has to deal with the legal requirements, and so to get that money back takes quite a bit of time. The example I gave at the lady this morning, the RAD was going to the children of the husband who passed away well before Christmas. Those funds are not far off now. We're 4 or 5 months on, not far off being passed through to the children of the deceased. But if you need it to live on, it's going to be pretty tough if it's locked up in the estate. So it's a complex situation.
I'm not sure whether we were recording when you mentioned it, Delta, but you were talking about was it the bucket or the box? What was the...
Tragedy box?
The tragedy box. And I was just going to go back to the article and talk about some of the maybe not superannuation, not necessarily estate planning implications of someone passing, because Muriel does a good job of touching on some of those. So she says, once all that is sorted, I have to go to the bank and the utilities and the house insurance and all the rest to change the names on the accounts. I'm dreading what paperwork that will require at the moment. I haven't got the strength to even ask. And then there's the cemetery. The family and I want my husband's ashes interred at the grave where his parents are buried, but there's no records at the cemetery as to who is the holder of right for the grave. That is effectively who paid for the grave in the first place, and so who has the authority for the interment. It was almost certainly my husband, but there's no paperwork to that effect, so we have to go through more complex paperwork to sort out the situation as well. Meanwhile, his ashes sit quietly in my dining room. Obviously, there are a few examples, but when we were talking just, I think, before we started recording about things like passwords and insurance policy numbers, what have you seen that's been sort of effective, or what some of our partners are doing, like our estate planning solicitors, what they encourage people to do as far as getting their house in order in readiness for?
Yeah,
I know it's morbid, I'm sorry.
This whole topic's morbid. We've got a local solicitor who actively encourages for her clients to prepare a tragedy box.
You can give Amy a shout out.
Okay, well, Amy of Succession Legal. This is a lot of work that she's put together, and basically it would outline, who the utilities provider is, whose name the mobile phone account is in, all of those types of household expenses, the insurance policy for the home, any of those pieces of information that would be required upon the passing of either party. In particular, if you think about, if you have a couple, generally one person tends to be, the bill payer and the manager of those types of things. So the other party may not know, banking logins or even the totality of bank accounts that might exist, or bank accounts in joint names. So the purpose of the tragedy box is to capture all of that information, not necessarily passwords, but that's something that perhaps could
I think we need to tell Amy to rename it from tragedy box to something else, but it certainly gets your attention when you think about it, though. It does. It's a motive. And
sorry, I think it even extends to things like your Facebook account and your Instagram and potentially unlocking your spouse's phone, and there's just so many things.
Passwords, PIN numbers.
A great example of that, unlocking your spouse's phone, which we were talking about earlier too. One of our lovely client couples had a tragedy in another state, sadly a massive stroke, and he was in hospital for about 3 days before they were able to. That family all got to see him, and they turned the machines off, the life support off, but everything was locked up in his phone, and they didn't even have the password to get into his phone, could not even get into his phone to get all the details of a variety of things. And the simplest thing, like accessing the phone, meant that family broadly, and sons with and daughter with pretty good technical capabilities, no one could get into his phone, and it sort of put a massive hold on a lot of things and a massive extra stress on that family at a horrible time. So how do you do that? You have a tragedy box, you have a folder, you have a file somewhere, you have access so that the parties who might survive you know where to go to look for some of that stuff.
I think part of that is actually as difficult as it is to have these conversations with your loved ones. Like, we've been very conscious over the course of the last few years because of ageing population and ageing client base. Obviously at our top end, our older end, we have clients every year that pass away. And what we've known and found from experience is that it's much better to have some of those conversations with your executors, your powers of attorney, your beneficiaries, your loved ones early on, so you can say, hey, here's where I keep a list of all of our policies, and here's how often I update it. Here are my financial advisors. Here's my solicitor. Maybe have a meet and greet. Introduce yourself so that you're not making that introduction at a difficult time. They sound like trivial things, but things are never a problem. Like you said, Peter, things aren't a problem until they are actually a problem, and then they can be catastrophic. I'm pretty sure we did a podcast with that exact title. Yeah.
But I think the get in, get out options, we talk about, over the years I've talked about that a bit, where if you're coming together in some sort of a partnership arrangement, making sure, it might be owning a house, whatever it is, making sure that you look to what the get-out options are when everyone's on good terms and everything's going well. So you set up all the structures so that it's locked in, and no matter what happens, death, trauma, relationship issues, all those things, when it comes to a get-out time, and someone goes to heaven, get-out time, well, it's already organised, it's already in place. And so the best time to put things in place is when nothing's wrong, when everything's going along swimmingly and everything's fine, because you've got a clear head then, and there's no time pressure, no emotional pressure.
That is succession planning. Succession in the event of death, succession in the event of a breakup of a partnership. So important, so valuable, and saves a lot of heartache in the end. I'm going to go to close out the article, and I'll point out that I don't believe Muriel is actually a financial advisor, but her statement here is some advice. So we'll assume it's not professional financial advice, but I think there's some good points in here. So talking to other recent widows, I've discovered my situation is just par for the course. Like me, these women are struggling with paperwork and rules and financial discomfort they never dreamed they'd have to face as they confronted their grief. Why on earth have we allowed bureaucracy to dominate our lives so heartlessly at such a painful time? I understand we have to protect against fraud, but surely we can do that without leaving vulnerable people at financial risk and without complicating at a time of grief so unnecessarily. Bureaucracy is not likely to get streamlined, so here is some advice for anyone potentially facing the situation or wanting to get their affairs in order just in case. Point 1, obtain certified copies of original certificates, birth and marriage. At this stage, have ready certified copies of identity documents, passport, driver's license, etc. Ensure you know where the latest will is, get certified copies, and have superannuation fund details ready. make sure you have enough money available to tide a widower over for at least several months after a death. And if you're contemplating an eventual burial or interment in an existing family grave, find out who the holder of right is to get that sorted. Obviously, there are only a handful, and a handful specific to Muriel's circumstances, and the ones that really stood out for her. We've probably already talked through the options. Obviously, we're not giving people specific estate planning or superannuation advice here, but is there anything else that we'd encourage people to think about in preparing for a worst-case scenario?
I think I touched on before, just estate planning goes right back to when you're thinking of buying a property together or buying a home or setting up a share fund or whatever that might look like, actually having some sort of understanding of, as you said, Peter, the get out clause if there is a need to, or the circumstances dictate that that's what has to happen. So yeah, I suppose just being mindful of that in the very early stages.
I think thinking beyond the immediate need or the immediate situation. As an example of a young couple who wanted some assistance to get a loan so they can buy a home together. And they've never actually lived together. They both lived at home and sort of moved backwards and forwards between respective parents' properties. But now they're about to go out, and we know if they've got a loan, beauty, they know how much they can borrow, they've got shared income, they'll service a reasonable loan, they're going to find a place. When we're chatting to them, we said, right, that's one thing. That's one piece of the puzzle that you need to look at. I'm going to own a home. We're going to go and get a loan and buy a home. From that, a million questions pop out. Many, many questions. Well, how are you going to own the home? In the event one of you is not around, in the event the relationship breaks down, like talk about it now when you're mates, you love each other, what happens when you don't? And then on top of that, how do you protect each other in the event that one of you is crook, one of you is unable to work, one of you goes? What will you do with the loan? So all the things that then talk through, and as a result of that, you need to structure the ownership correctly to meet what they want it to look like. You need to structure wills, which they didn't have. How do we put wills together? Who's going to own if one of you goes? How is it going to work? Do you need right to life residency if one of you in the home in your will? Those sorts of things. So out of this simple thing, we want to come together. We love each other. We've been together for a couple of years. We're going to buy a home together. That's one simple piece of the puzzle, but that jigsaw puzzle for them was about 8 or 10 pieces.
As you say that, you can see, for those people that are doing it on their own, that is just overwhelming. Like you're thinking about your first home, you're excited about buying your first home, you're probably not thinking much other than, is the bank going to give us enough money to get it? Let's get the house. It's very emotive. You're not thinking 3, 4, 5 steps ahead. You're definitely not thinking 10, 20, 30, 40 years ahead, which again comes back to the importance of surrounding yourself with the right people who can at least bring those things to your attention. It might be things that you actually address yourself. They might be simple things that you just hadn't thought about that can be easily dealt with yourself, or they may be significant potential issues that someone can point out and can stop you from making a catastrophic error right at the start. Like you said, if you can get the right plan, the right structure in place as you're acquiring assets, as you're putting things in place, then when we spend all this time as financial advisors growing wealth, to have it lost or to not protect it or have it not go to the right people at the right time is pretty devastating. It's why we bang on about it probably ad nauseum.
And to that point, Jay, I think it's sad how many instances and scenarios that we could reel off around family units that everyone was happy and everything was good until mum or dad passed, and then all of a sudden, there's dad promised me this, or, whatever the circumstances are, that unfortunately happy families are no longer happy families.
It can easily happen. There's just come back to that sort of question about the one thing or having a discussion around other possibilities, and it's not a perfect analogy, but I talk about the Jiminy Cricket syndrome, which is more about your conscience. But our job, I think, often is to challenge or ask a challenging question. So if this happens, what would you want to happen? And throw those scenarios out there. And we won't create the answers because people have got their own personal preferences. They know what it is they want. But unless the question is asked of them, they probably don't think, well, if that happens, what would I do? And so I guess that's part of it, is to know that there's a myriad of possibilities where you throw all those questions at the individuals or the couple, whoever they might be, and get them to give some feedback. And, before we usually take someone off to get a will, we say, look, answer some of these questions or come back with answers to some of these things, have a chat. Let's write up a script. Let's write up your script so that we can have a conversation with you about what you want it to look like. Then we can take you to the solicitor who'll put it all in legal speak and make it work legally. But unless you go with a script, a story of what you want it to look like in the event something goes wrong, and most people don't want to think about it going wrong. That's the challenge. So we've got to almost confront people with if it goes to shit, what would you like it to look like? Young couple, if in 10 years' time you actually break up, you don't love each other anymore, what do you want it to look like? I don't want that to happen. You'll be together when we die. It'll be 40, 50 years from now before that happens. But just in case, what would you like it to look like? So let's look at what we can do to protect that if it does happen.
Perfect. Delta, do you want anything more before we wrap it up? I think that was a pretty good summary of that article. And I think what it definitely says is that there's complexity in estate planning. And I keep thinking about, this is just one scenario with Muriel and her husband in their obviously age pension and beyond. So they're sort of in their probably late 60s, 70s. Got all of the scenarios that you spoke about, Peter, of young families with dependents and debt and insurance needs combined with superannuation that maybe complicate or add questions around how to best manage your estate planning. So it's not unique. That estate planning discussion is not unique to people in the latter stages of their life.
Right.
In fact, it spans the full spectrum of people, from people with their first job all the way to people who are in aged care. So,
and set up correctly, it can be streamlined. It doesn't have to be, another massive headache at a really difficult time in your life.
You can't remove the traumas and you can't remove the anomalies that will appear, but you can fine-tune it and get as much as it possibly can in place so that as much as possible will go reasonably well at times when everything else around you is going to hell because you're going through this horrible emotional time, whether it be a relationship breakup, situations with family members, or the death of your partner. Like, there's a range of things that are going to make it tough anyway. Make it as easy as you can by planning in advance and putting as much in place as you possibly can. Then you've got some degree of confidence that it'll be reasonable. It's not going to be perfect, but it will be reasonably okay.
Great way to wrap it up. Thanks, PB. Thanks, Delta.
Thanks, JB.
We hope you enjoyed today's episode. If you're keen to understand more about how financial advice could benefit you, follow us on Instagram, Facebook, and Twitter at Burke Britton FP, or Google Burke Britton Financial Partners. Check out our client reviews, testimonials, and make a time to meet one of our certified financial planners by clicking Book Now on our website. Thanks for listening.
Any information contained in this podcast is of a general nature only. No account was taken as to the objectives, financial situation, or needs of any particular person. Therefore, before making any decision, listeners should consider the appropriateness of any information with regard to their particular objective, financial situation, needs, and seek independent advice from a licensed professional specific to their circumstances.
All right, hit it.
That translates to, don't be a moron and act on what some random person says on a podcast. Take personal responsibility, do your homework, ask questions, and speak to an actual human that knows what they're talking about before you do anything. PB Financial Solutions Proprietary Limited, trading as Burke Britton Financial Partners, are authorised representatives of AMP Financial Planning Limited, AFS, licence number 232706.